Hi, welcome to these video lectures that are a companion to our course in school law. In this opening lecture, we're going to focus on the legal framework that affects public schools, really starting with the historical overview of schools, education law, and policy, and the American political system in general. Much of this may seem like a review of a basic high school or undergraduate course in government. But the American political system is really important to review and understand because the system is unusual in that it's built on a concept called federalism, which is the separation of powers. It was developed by the founding generation based on a concern for overly powerful government. As a result, there are several layers of government within our political process and our political system. The federal government at the national level, state governments, and local governments. And of course, schools apply to all three of these, as there are federal elements of school law and school policy, state, and of course, there are local levels at the district, the Board of Education, and the school level. And so let's look at just the origin of schools because that will help us frame some of the challenges that we're going to talk about in this course. The origin of schools in the United States, if you look at the history, is tied to religion and tied to teaching people how to read the Bible. In fact, much of the origin has its roots in Puritan New England and Massachusetts and the idea of what is called the deluder of Satan laws, which were really formed out of the notion that people needed to be able to read the Bible as a basis for understanding and developing habits that would allow them to delude evil. The first laws on the books in education are in Massachusetts. Much of these laws that originated, they originated around the middle of the 1800s, the 19th century. They originated around an individual named Horace Mann, and he advanced the idea that education was a function of government and a function of the state, and that the state had a function and responsibility to educate citizens. As a result, much of the early history of education and the formation of education came through the state level in constitutional provisions. As states were admitted to the Union, the idea of free, thorough, efficient, uniform, adequate systems of education began to dominate. In fact, in the state of Kentucky, there's a lot of language that's very similar, focusing on words like free, efficient, adequate. Of course, these are all terms of art and not science. And so legislatures and courts have often had to act and interpret what each of these mean. But overall, the precedent was set very early that education was a function of the state. And so there are a lot of different ways and different methods that we'll talk about in this course. And first and foremost, the framework will be based on the sources of law. And of course, our Constitution, the Constitution of the United States, was one of the first and earliest formal constitutions. It was developed and ratified in 1789. But it does not say anything about education. And so education being sparsely, if not at all, considered, a lot of questions through the history of American education really are about the role of the national government. And that role was very small because of its absence from the federal Constitution. So constitutions then existed at the state level, and Kentucky Constitution addresses education very thoroughly. We'll talk about that in some detail. Statutes are laws that are made by local, state, federal officials that govern many elements of the legal system. Some of those, as far as education are concerned, at the state level are laws like the Kentucky Education Reform Act, or at the national level, ESEA, the Elementary and Secondary Education Act. And so these are two examples, one at the state, one at the federal, where statutes govern education laws. And as they're called, of course, regulations are what agencies then have to do to enforce that law that's created by the legislative branch. And they allow them to create a framework for enforcement of the law that was created. These are the regulations, and those regulations, the administrative bodies that administer that in the executive branch, or the Department of Education in each state and at the national level. And of course, we are going to talk a lot about judicial decisions and case law, and we're going to go into details about the judicial system here in a moment. But these set legal precedents, which many decisions are made and policies are set based on that. Lastly, we have administrative law and board policy, and this comes typically at the local level, where administrative agencies and boards of education create policies which they enforce everything from constitutional provisions to the statutes that are passed at the legislative level to the regulations that are promulgated at the administrative level by the executive branch. And so this goes all the way down to what happens with boards of education. And so the federal role we mentioned is absent in the Constitution, but there are some early elements of the federal role that began to emerge. As states were admitted to the Union, and the land ordinances that admitted states like Ohio and Indiana and Illinois, the Northwest Ordinance, there were provisions that the 16th section of land, 5% of the funds be set aside and dedicated to education. And the precedent was set very early on that as new states were admitted to the Union, there would be a required education clause in state constitutions. And so that sets the precedent very early on that education is a state concern, but that a right to an education supported by the government was also something that was a prominent idea. And so some other elements that began to emerge at the national level were these three acts, the Morrill, the Hatch, and the Adams Act. These were land grants, and these were grants and aid to the states. Many of these pertain to higher education. In Western states, many land grants that existed were granted for the purpose of creating universities. The University of Kentucky was created by the Morrill Act as a land grant in Lexington, for example. And of course, there is a provision in the Constitution, in the preamble of the Constitution, that refers to the general welfare. But there's also provisions called the Commerce Clause. And that Commerce Clause that talks about the general welfare and the importance of things that you can do to promote the general welfare and regulate commerce. And those are part of the importance of what we see. One of the last things that I think is important to understand is the 10th Amendment, and that's something called the Supremacy Clause. And that Supremacy Clause is that it states that if it's not mentioned in the Constitution, then it is a duty and requirement of the state to administer. And that state supremacy through the Supremacy Clause in the 10th Amendment becomes the basis for not establishing a national system of education, but establishing state systems. Because it's not mentioned, it is reserved to the state. Sometimes it's called a reserved power. We're going to talk a lot here in a moment about the Bill of Rights, the 14th Amendment, and how that affects education. But there are also lots of federal statutes that are applicable and important, everything from ESSA, which is the latest iteration of the Elementary and Secondary Education Act, which was formerly known as No Child Left Behind, NCLB. But there are also our civil rights acts that were passed in the 60s that created the Office of Civil Rights that talks about protecting the rights of individuals. There's EEOA, the Education Equal Opportunity Act. There's IDEA and its successors that talk about individuals with disabilities. And then there's Title IX of the Education Amendments that has mostly to do with gender equality. So all these are federal provisions that impact education that we're going to talk about. The last thing that I want to talk about as we get into this introduction is I want to talk about the state level. Kentucky Constitution, like all state constitutions, has a very specific provision related to education. Sections 183 to 189 are dedicated to education and what we call the common schools. The Kentucky Revised Statutes are the statutory law that govern the operation of education. So all of Chapter 13 focuses on education. If you go to the Kentucky Law Book that you can find online, it's listed in the syllabus, that has the entire Chapter 13 represented in it for the KRS. And of course, in Kentucky, the Kentucky Education Reform Act of 1990 that came out of a very important court decision that you're going to read called the Rose decision. That act is really what shaped most of Chapter 13 in the modern era for those of us that are working in schools. And if we're looking at the differences between this legislative piece that come from things like constitutions and statutes and acts, then the executive branch, what we call an SEA, the state education agency, is the Kentucky Department of Education. And the Kentucky Department of Education is an entity that has a board of education that is independently operated, and all members are appointed by the governor. It does set some education policy, and it oversees the work of the Department of Education. It does have some legislative oversight. And of course, the Commissioner of Education is what we call the Chief State School Officer, CCSO. It's called that because in some states they're commissioners. In some states, they're called superintendents of public instruction. Some cases, they are secretaries of education. So because the titles are different based on every state, they just simply refer to them collectively as chief state school officers. In Kentucky, it's the commissioner. And so there are differences that we will discuss a good bit in this course about statutes that are passed by the legislative branch and regulations that take those statutes and administer and promulgate those regulations for operational purposes. And that's what the Department of Education does and the boards of education do at the state level and even at the local level. And so they take statutes and turn them into regulations and administrative law or policies. And so that's how the different branches of government operate. So if you look at these different branches of government, the legislative branch of government is the one that makes the laws. In the national level, it's Congress. It's the House of Representatives and the Senate together that form Congress. At the state level, it's a state legislature. In Kentucky, it's called the General Assembly, and it also has a House of Representatives and a Senate. Those two together form the basis of the lawmaking authority. And of course, the executive branch has a part of that. The president and the governor have to sign that legislation, or they can veto it and send it back, and the legislature can override the veto if they have enough support. They have to have a super majority, of 3/4 of the votes to be able to override those vetoes. So, but the executive branch in each entity, you also have administrative departments, executive departments at the U.S. level. At the federal level, it's the U.S. Department of Education, headed by the Secretary of Education, which is part of the president's cabinet. At the state level, we just talked about the SEA, the State Department of Education, the Kentucky Department of Education, or KDE, and of course, the commissioner is hired by the state board. So as we delve into some of the details of the legal system here, we want to focus a little bit on the Bill of Rights, which is the first 10 amendments to the U.S. Constitution. These are the primary source of individual rights and freedoms that we're going to talk about relative to students and employees in school districts. These first 10 amendments, they're viewed as the fundamental liberties of free people because they place restrictions on the government's power. And so the belief here is that the Bill of Rights doesn't grant you the freedom of speech, that you have freedom of speech as a free person. The First Amendment to the Constitution just limits the government's ability to restrict a right that you're born with. So that's a fundamental difference that I think a lot of people misconstrue, is that you're granted the right by an amendment, by the Bill of Rights, by the First Amendment. That First Amendment limits what the government can do to restrict a freedom that you're born with. I'm going to talk a little bit also about the 14th Amendment. And the 14th Amendment is an amendment that has some basis for the applicability of all those 10 amendments in the Constitution at the state level. And so we'll talk a good bit about that, that relationship between the different Bill of Rights and the different freedoms, because the First Amendment talks about the national government not restricting your right to free speech and other freedoms. The 14th Amendment says that that is applicable to state law too, because prior to that, the interpretation was that the U.S. government couldn't restrict your basis for free speech, but the state could if they wanted to. It didn't apply to the states. But the 14th Amendment comes along after the Civil War and says, no, states can't do that either. The 14th Amendment protects individual freedoms from not just the national government, but from state governments as well. So the Constitution is the primary source of law, and it provides the framework for all these processes, and all statutes that are enacted really are subject to Constitution. And that is something that is there to protect all the rights of citizens of the United States. And again, these are inherent rights. We talked about how it doesn't make reference to education. And we also talked a bit about the 10th Amendment and the federal Constitution. Powers not delegated to the United States by the constitutions nor prohibited by the states are reserved to the states, these reserved powers. So state constitutions represent the basic source of law when it comes to anything that's not listed in the federal Constitution, and specifically for our case, public education, really majority of which rests with the state. And of course, a lot of the funding and operational schemes for public schools emanate that way from state government and from state constitutions. And so there's no contradictions allowed. And so sometimes you have that as a basis for some of the discussions in law. And of course, we introduced the idea of statutes. These statutes represent an act of the legislative branch of government. They are the most abundant source of law that affect public schools. You read every day as the General Assembly is in session about this law or that law that they're proposing that applies to schools. School district policy are rules and regulations that are generally based on those statutes. It's a way that the local district, the local board, administers those rules and policies from that statutory law. There are very few things that boards of education actually do on the local level that constitute anything new and different. And of course, nothing can contradict what the state does or what the federal government does. And so they represent the most effective means for developing new laws, changing old laws, and setting policy in education. And so state legislators are the groups that grant local school boards the authority to adopt and enforce these rules and the operation and management of the schools, the duties of the board, the duties of the superintendent, even the hiring of the superintendent, and how the superintendent's evaluated is set up in state statute. So let's shift and talk a little bit about court or case law. Case law is generally reflected in judge-made decisions. It's different from statutory law. Statutory law is what's passed by the legislative body. Common law or case law is that comes from a judge's decision that interprets existing statutes or the Constitution. Sometimes there's a dispute as to whether a statute that's passed by the legislature conflicts with the Constitution, and then it's up to the judge, the judicial branch, to make that determination. And so common law are these judgments, opinions, and decisions that courts make, adopting and enforcing proceeding, and these things are called precedents. We mentioned state boards in our historical overview, and these are administrative agencies created by the state legislature. They determine the direction of education in the state, and public schools are placed under the authority of these state boards, and they develop policies governing areas such as health, safety, licensure, graduation requirements, things that are relative to the needs of the state based on the statutes that were passed by the legislature. Local boards impact education policy and the administration and supervision of public schools at the local district level. Their broader role involves the formulation of school district policy, which has to be consistent, again, along the way with statutes that are passed by the legislature and how they're promulgated through the regulations at the state level. These policies that are done at the local level are accompanied by rules and regulations that provide a direction of more specific operation of schools in the locality. So let's finish off with a discussion of the court system. The judicial branch, the judicial system, one of the three branches of government. We've already talked about the legislative and the executive. And so this judicial system consists of federal and state courts, just like our federalist system. You have the federal and the state level. The organization of these courts at both levels is essentially the same, starting with the trial court, then the intermediate courts of appeal, where you appeal a trial decision, and then the highest court of appeal. Each state has a Supreme Court. If it's a federal system, then there is the U.S. Supreme Court. And of course, decisions that go to state Supreme Courts that still go to appeals can be appealed to the U.S. Supreme Court as the final arbiter for those decisions. Federal courts typically deal with cases that involve federal or constitutional issues. If someone's violating IDEA, disabilities, or violating the U.S. Civil Rights Act in your schools, that will go to a federal law because it's based on, or federal court because it's based on federal law. The federal court system includes district courts. There are district courts in the major cities in Kentucky, including Owensboro, Bowling Green, Henderson. But there also are appellate courts, and those courts, many cases, those appellate courts are groups of judges that will sit in different locations around the state. And then, of course, the Supreme Court at the federal level, these appellate courts reside in major cities. The appellate court that focuses on Kentucky is in Cincinnati. But each appellate court, there are certain districts that are certain appellate jurisdiction zones. And of course, we're in the Cincinnati zone for the federal level. As I said, at the state level, they rotate around. And of course, the Supreme Court is at the seat of government in Washington and at the state level in Frankfurt. You can see 95 district courts in the United States, at least one federal court in each state. Larger states have more. And they usually hear cases between citizens of different states as well, if that comes up. It doesn't come up that much in education. We talk about the circuit courts of appeal, 13 circuits in the United States, 11 in geographic jurisdiction over a number of states, and then one in D.C. that focuses on special issues. We're one of the, Cincinnati is one of those 11 geographic jurisdictions that I mentioned previously. The primary function is to review proceedings from lower courts and determine if errors of law as opposed to facts were committed, and if there were procedural irregularities and constitutional misinterpretations or inappropriate applications of evidence in those proceedings. State courts, again, are part of the state judicial system, do the same thing at the state level. Many of the education cases are heard in state courts because they don't involve federal questions. They involve questions of state authority over schools. The courts of general jurisdiction are often referred to as district or circuit, and their jurisdiction covers most cases except those that are going into special courts. In most instances, they are appealed to courts of appellate jurisdiction at the state level, and then ultimately to the state Supreme Court. The difference between the district and the circuit court is really often a difference of severity. If it's a more severe case, or if it requires higher dollar amounts, if it's a lawsuit, then it will go right to the circuit. Many minor cases will start at the district level and work their way up from there. As I mentioned previously, the appellate court, the Court of Appeals, rotate around the state. They travel around the state. We have an appellate judge in Owensboro, and there are appellate judges scattered all around the state. The state Supreme Court is seated in Frankfurt. Courts of special jurisdictions are really there to hear legal disputes on special matters. They generally referred to as trial courts, and they have limited jurisdictions. Some are called municipal justice of the peace, probate, small claims. In Kentucky, we have family court, which is where a lot of school things go, and that is an example of a special jurisdiction that deal with family issues. Intermediate appellate courts have emerged to hear appeal cases. Again, we've talked about this. Their primary role is reviewing proceedings from trials and determine if things are substantially correct, no procedural errors, and the way the law was applied. The Supreme Court is the highest court. Unlike lower courts, there's no appeal beyond the decision of this court. The Supreme Court's ruling can only be overturned at the state level. State Supreme Court can only be overturned by the U.S. Supreme Court. If it's a U.S. Supreme Court decision, the only way it can be overturned is an amendment to the federal Constitution. In the case of the U.S. Supreme Court, there are 9 judges, including a Chief Justice of the High Court, and of course they are appointed to terms of life. Actually, technically, the way the law is written, the Constitution, it says good behavior, because they can be removed for inappropriate behavior. So it's not necessarily life terms, it's good behavior. Cases that reach the Supreme Court in 2 ways, typically on appeal, where it's appealed to the and by something called a writ of certiorari, which is where the justices review an issue and determine whether they need to weigh in on the issue. And if the majority of the justices say they need to weigh in on the issue, then they will grant what they call a writ of certiorari. An example of this more recently is when the justices decided that they wanted to hear an affirmative action case. You've also seen this with issues like the transgender bathroom cases, where they're deciding to rule. The previous courts have decided not to rule. And if they decide not to rule, the decision from the appellate court stands. That becomes the law. If they grant writ of certiorari, then the case goes to the Supreme Court for its proceedings. And we'll be focusing on mostly those cases that go to the Supreme Court and looking at the case law as we dig into education law and policy.